This is Barry Zalma on insurance. I'm an attorney who's retired from the practice of law and now spend my time as an insurance claims consultant and expert witness, and author and producer of these videos. Today I'd like to talk about the loss in progress rule that has been described as follows. Quote, "The point at which a threat of loss is so immediate that it may fairly be said that the loss was in progress and the insured knew of it at the time the policy was applied for or issued, and that is generally a question of fact. Consider Sentinel versus First Insurance Company and Inland Waters Pollution Control, Inc. versus National Union, a Sixth Circuit case from 1993. At least one court has seen the loss in progress rule as an attempt to swallow up the expected or intended exclusion. The defense is independent of the exclusion for losses that are expected or intended by the insured. A majority of states have overruled the old marine rule under which a false representation of fact that the insured warranted to be true automatically voided coverage, regardless of the materiality of the misrepresentation. In Chemstar Inc. versus Liberty, a 1993 Circuit Court decision, the court concluded that since an insurer may only insure against contingent or unknown risks of loss, a policy issued after the loss is in progress has begun does not cover the loss. The California Supreme Court in Prudential LMI versus Superior Court, a 1990 decision, made it clear that there is a stark difference between first and third-party insurance. The California Supreme Court said, quote, "As one court observed, in first-party cases applying the rule finding coverage only on actual occurrence of injury, no damage or injury of any kind has taken place until it manifests. The cause instead lies dormant until it is later causes appreciable injury. Thus, a third-party insurer can be responsible if it fits within any portion of a continuing loss, while the first-party insurer is only responsible if it is on the risk when the loss first manifests itself. The Prudential LMI case limited the application of the decision, therefore, to first-party insurance. Recent Court of Appeal decisions have found that the difference is illusory when discussing the loss in progress rule. In Inland Waters Pollution Control versus National Union, a 1993 decision of the Sixth Circuit applied the loss in progress rule to a third-party case. The court held that the loss in progress rule operates only where the insured is aware of a threat of loss so immediate that it might fairly be said that the loss was in progress and that the insured knew at the time the policy was issued or applied for that the loss was ongoing. In Montrose Chemical versus Admiral, a 1995 decision of the California Supreme Court, it set the issue to rest as follows, quote, "We conclude that the standard CGL policy's language, such was incorporated into Admiral's policy and issue, provides coverage for bodily injury and property damage that occurs during the policy period. In the case of successive policies, bodily injury and property damage that is continuous or progressively deteriorating throughout several policy periods is potentially covered by all policies in effect during those periods. Stated in the insurance company's parlance, we conclude that continuous injury trigger of coverage should be adopted for third-party liability insurance cases involving continuous or progressively deteriorating losses. California courts have long recognized that coverage in the context of a liability insurance policy is established at the time the complaining party was actually damaged. In Remmer v. Glens Fallen, 1956 decision of the California Court of Appeal, the court was asked to interpret the definition of occurrence as that term was used in a CGL policy. The precise issue in Remmer was whether the act of defectively grading and filling a lot constituted the sole occurrence giving rise to coverage under the policy's one occurrence provision, or whether subsequent injury, an alleged maintenance of a nuisance on the graded lot adjoining the third-party claimant's property, also triggered liability coverage under the policy. Relying on cases from California and other jurisdictions, the Remmer court formulated the following rule, subquote, "The general rule is that the time of the occurrence of an accident within the meaning of an indemnity policy is not the time the wrongful act was committed, but the time when the complaining party was actually damaged," close subquote. The Remmer formulation, which distinguishes between a wrongful act and the injurious result of the act and holds that the triggering of liability coverage under a CGL policy is established at the time the complaining third party was actually damaged, has been embraced by noted experts like Appelman, Couch on Insurance, American Jurisprudence. All have been accepted by the courts of many other states and has been cited by federal courts interpreting the law of still other states. Close quote. On June 22, 2010, the Supreme Court of Ohio decided Pennsylvania General versus Park Ohio Industries, in which it was asked to revisit the all-sums allocation method of insurance coverage for progressive injury losses, such as asbestos claims, spread over multiple triggered insurance policies. Under that approach, the insured may select or target one policy issued by one insurer. The Supreme Court reaffirmed the all-sums method recognized in Goodyear versus Aetna and declined to adopt competing pro rata allocation methods. Additionally, the Supreme Court held that the insured has a duty to cooperate with the targeted insurer to identify other policies and insurers which may provide coverage for the loss. The targeted insurer may then seek contribution by non-targeted insurers. Failure to timely notify a non-targeted insurer of a pending claim does not automatically make that insurer's policy inapplicable for contribution to the targeted insurer. Further, lack of notification to a non-targeted insurer will bar the targeted insurer's claim for contribution against that non-targeted insurer only if the failure to notify resulted in prejudice to that non-targeted insurer. In Penn General, the insured settled the claim after giving the targeted insurer notice, but without the targeted insurer's formal consent. The insured then sued the targeted insurer for coverage of the settlement, but did not notify the targeted insurer of the other policies issued by other insurers for approximately 2 years. the targeted insurers sued the non-targeted insurers for reimbursement based upon their respective shares. The non-targeted insurers asserted they were prejudiced by the late notice of the claim and that the settlement reached without their consent violated the consent to settlement clauses in their respective policies. The Supreme Court disagreed, holding that because Goodyear created an equitable approach to the unique situation surrounding the allocation of liability in progressive injury cases, the insured's notice to the non-targeted insurers can be seen as being within a reasonable time in light of all the surrounding facts and circumstances. Writing for the majority, Justice Lansinger reasoned, quote, when loss or damage occurs over time and involves multiple insurance policy periods and multiple insurers, a claim may be made by the targeted insurer against a non-targeted insurer with applicable insurance policies for contribution, close quote. He did so because the all-sums allocation method established in Goodyear is a remedy that is equitable in nature, and we clarify Goodyear by stating that the insured has a duty to cooperate with the targeted insurer. In addition, the Supreme Court held that only where failure to provide timely notice results in prejudice to the non-targeted insurers will contribution by non-targeted insurers be barred. The court found that denying the non-targeted insurers initial notice of the claim litigation and the ability to control the defense, defend their interest, investigate the claim, choose counsel, set litigation strategy, and control settlement do not amount to prejudice because they are the natural result of Goodyear's all-sums approach. The court held that the non-targeted insurers were not prejudiced as a matter of law because the terms of the settlement were reasonable and delaying notice to the non-targeted insurers was not unreasonable considering the Goodyear rule. 3 justices concurred. Justice Lundberg Stratton concurred in part, but dissented as to the majority's conclusion that the absence of prejudice was shown as a matter of law. She would have remanded the case to the trial court for a factual determination on that issue. The recently appointed Chief Justice Brown did not participate in the decision as the case was submitted to the Supreme Court prior to Chief Justice Moyer's death. In most situations dealing with third-party insurance claims, the issue is when the damage occurred, whether it manifested itself or not. The loss in progress rule works in third-party cases only when the insurer can prove that the insured knew the loss was in progress before the policy was acquired, and it would prejudice the rights of the insurer if it was held to pay to defend or indemnify the insured. The California Supreme Court destroyed the applicability of loss in progress rule in most third-party liability claims by the following language, quote, although it is true that the loss in progress rule is codified in California Insurance Code Section 22 and 250, draws no distinction between and thus is applicable to first-party property insurance and third-party liability insurance policies. The distinctions inherent in the 2 types of coverage necessarily result in different analysis when the rule is applied in the liability insurance context. As we have explained, first-party property insurance policies provide coverage for damage to the insured's own property. In that context, insurance cannot be obtained for damage which has already occurred because the absence of risk precludes coverage. Third-party liability insurance policies, in contrast, afford coverage for sums which the insured shall become legally obligated to pay as damages because of bodily injury or property damage. In the liability insurance context, insurance cannot be obtained for a known liability. Where, however, as here, there is uncertainty about the imposition of liability and no legal obligation to pay was yet established, there is an insurable risk for which coverage may be brought under a third-party policy. The fundamental contractual duty of the insurer in the third-party case is to pay such judgments as shall be recovered against the insured. In the usual first-party case, the promise of the insurer is to pay money due under the policy to the insured upon the happening of the event, the risk of which has been insured against. This video was adapted from my book Zalma on Insurance Claims Part 105, Second Edition, which is one of a 10-part treatise, Zalma on Insurance Claims, which are available from Amazon.com as both Kindle books or paperbacks. If you found this video to be interesting or useful, refer it to your colleagues. It's free. And please subscribe to my YouTube channel, my Rumble channel, and my blog so that you can be advised of future videos and future blog postings. Thank you for your attention.